Legal Integration of Islam, a Transatlantic Comparison by Christian Joppke and John Torpey sets out to provide a comparison between countries in Europe and North America in regard to the legal integration or lack thereof of Islamic law. The book provides a basic outline of the topics it hopes to explore, of which there are three. The author set out to offer a dynamic account of institutional responses to Islam in several major Western countries, to show the centrality of the legal process in Islam and Muslim integration, and also provide that transatlantic comparative perspective that's advertised in the book's title. The book is structured in a way that introduces its purpose before getting to the specifics of Islamic integration in four countries: Germany, France, the United States, and Canada. These countries were chosen to highlight the differences both within and between North American and Western European countries when it comes to Islamic integration of Islamic law. So the authors Joppke and Torpey provide a hypothesis at the beginning of their work that the conflicts Muslims are currently experiencing are tied to issues of balancing the existing majority's legal practices with those of the emerging ethno-religious minority that are Muslims. They theorize that a key factor in the struggle between the old and the new is the existing legal system of the state, higher courts in particular, that determine individual freedoms and liberties and strive for equality amongst all citizens. The reader can extrapolate from this thesis and hypothesis that the research question is, what are the root causes of the struggle of Muslims to establish themselves in Western countries? And how are different countries reacting and adapting legally to the increase of their Muslim population? After the introduction, the book gets into the specifics of what makes Islamic law integration differ between and within Western Europe and North America. Beginning in Western Europe, Joppke and Torpey provide an analysis and background behind France's recent legal rulings that have negatively impacted practicing Muslims within their country. And this includes the 2004 judgment against wearing regular headscarf in public schools, and the 2010 judgment that restricts face coverings in public spaces. These burqa bans, as they came to be referred to, came as a result of assertions that these face coverings were a sign of subjugation and debasement. And this is not something that the French really wanted represented in public spaces. The most interesting part of the discussion is the exploration of how France's history with the religious integration becomes relevant to the conversation about Islamic law integration. And that's tied to France's 1905 law on the separation of churches and state, which does what it sounds like, and really set the standard for the fact that the country has long resisted any state support of any particular religion. The state has, however, been able to fund things such as mosque construction by justifying them as cultural centers instead of religious centers. And this distinction motivated activists to question whether or not French legislators should consider face coverings as religious or cultural garb. That was the most interesting part of the discussion of French integration of Islamic law to me. In the next chapter of the book, the authors compare the integration of Islamic law in France to integration of Islamic law in Germany, where they're sort of having the opposite problem they're having in France, because where France faces limits of integration tied to the exclusion of Islamic law in its pre-existing legal system, Germany faces limits of inclusion. What this means is that Germany has a very different background when it comes to religious integration in the past, and has a very different system in place. So what Germany does is it cooperatively links church and state to the point of providing recognized religions with public status and functions. And with this public status, which requires the religion's cooperation with the state, religions are able to be taught about in public schools, and religious communities are given public corporation status. The conflict in Germany largely comes from the struggle to determine what amount of multiculturalism is too much in the eyes of the majority of the non-Muslim population. This leads to issues related to the fact that Muslim children are often not taking part in activities such as swimming, sex education, and events around the time of Islamic holidays, due to the recognized legal status of Islam. And this leads many non-Muslim Germans to question the compatibility of Islamic law with the pre-existing German culture and German consciousness. So the authors of the book then talk about Canada. And in Canada, the country takes a more European approach than the United States does when it comes to enacting a top-down policy of multiculturalism that tries to accommodate cultural diversity by way of like explicitly stated norms about how to handle difference. The Muslim population of Canada is relatively small, and it does not share Europe's history of fearing Islam due to its distance from Muslim-majority countries, which Europe doesn't share, given the proximity of the Middle East and the Holy Land to Europe. Because of this, Islamic integration has largely flown under the radar, but has come up in circumstances where a few outspoken Muslims have made a push for legitimate progress. An example of this comes from the 2003 announcement that lawyers at the Islamic Institute of Civil Justice would be conducting arbitrations in accordance with Islamic personal law, and that this endeavor would constitute the nucleus of a Sharia court. So concerns arose about the concept of a Sharia court operating in a Western country in a post 9/11 world. And some of the fears that came about in Canadian society came about because people were worried about women and children who would not be able to participate in any of the arbitration hearings that would happen at this court, and also that people were concerned for consistency due to the various different interpretations of Sharia. People didn't know what the precedents would be and what rulings this court would dole out. The arbitration court was ultimately rejected by the Canadian government, but raised an interesting conversation on where Canada stands when it comes to Islamic integration, one that does not come up as much as it should. In the United States, Muslims have had a shifting and adapting face to the times. In pre-September 11th America, Islam was most commonly associated with black Muslims and the Nation of Islam, which was sort of a domestic view of Islam. However, in a post-September 11th America, Islam was largely seen as a foreign entity coming into the United States, trying to declare agency, and has the face of an immigrant. Despite public opinion being so harshly against Muslims in the United States after September 11th, the community has had a much easier time navigating the courts of law and public policy. The prime example posited by the authors is the non-issue of the legality of wearing head coverings. Muslim women have not had to face issues from the courts as to whether or not their garb was legal, and it is recognized as a public expression of their faith and culture. Though there have been several issues of legality of Muslim practice in the United States, most often the courts rule in favor of the complainant, and that sets the precedent that Muslims are allowed to operate within American society while holding on to the beliefs and practices of their faith. And this isn't to say that there are no issues that Muslims face within American society, because the foreign policy of the country has been identified by many other countries as to be unjustifiably targeting of Muslim populations in the world. There's also something to be said about how public perception influences policy and how important it is for these countries to move the narrative away from Islamophobia and toward inclusion and toward integration of Islamic law, because this isn't something that's going away. The population of Muslims in the world is rising, and it's really important for us to focus on integration over exclusion. So, Muzammil Siddiqui discussed the state of American Muslims in his 2014 article, Interpretation of Islamic Law and Muslims of America, and addressed the fact that the laws of the land in America, the Bill of Rights, the Constitution, and the Declaration of Independence, do not go against the laws of Islam in language, and Muslims can honor common law and Sharia law in the United States. So this includes laws about marriage, family law, inheritance, and banking, to name a few. There have also been efforts, as there have been in Canada, to establish Islamic arbitration committees to settle personal disputes, though public perception of this sort of thing is still weird and it's still negative. It is something that people are trying to do to sort of help Muslims balance the common law of America with Sharia and Islamic law. Haider Ghulam noted that although Sharia is a necessary part of a Muslim's everyday life, a nation does not need to have Sharia law explicitly stated in the laws of the land to be within Sharia. This understanding, when applied to legal integration of Islam, a transatlantic comparison, provides the reader with a template to navigating the complex world that is Islamic legal integration. Though reaching some level of integration of Islamic law is good for Muslim members of society, It is not necessary for Muslims to operate fully and freely according to Sharia.